So I'm Krista, and I'm going to be talking about transfer on death deeds. So what is a transfer on death deed? It's also known as a beneficiary deed. It's a document that would allow a property owner to designate a beneficiary who will automatically inherit their property upon the owner's death. And it's done primarily to avoid probate. So there are some advantages of transfer on death deeds. The most important one and primary is avoiding probate. As long as it's executed properly, you can avoid probate and transfer the property without the costly and time-consuming probate process. Simplicity and flexibility. So it's relatively straightforward compared with setting up a trust. It does require a notary and 2 witnesses, and then also to be recorded within 60 days of being notarized. But it is relatively simple and flexible. So the homeowner would retain control during their life. So instead of just giving away the property, it allows the property owner to retain full control and ownership of the property during their lifetime. So they could sell, mortgage, or deal with the property as they see fit. It's also revocable, which means that the property owner can change their mind and revoke the deed or change the beneficiary designation at any time. So establishing a transfer on death deed could be more cost-effective than creating a living trust, which usually involves a lot of legal fees for drafting and administration. It avoids conservatorship. So if the property owner becomes incapacitated, there would be no need for a conservatorship, since the ownership would still remain with the property owner until their death. And also for the beneficiary, they can get a step up in basis to the property's current market value, potentially reducing capital gains tax if they decide to sell the property. There are disadvantages of transfer on death deeds as well. So one is that it's restrictive on the type of residences that it allows to transfer on death. So it would have to be either a home, condo, farm of 40 acres or less, or a multi-unit building with no more than 4 units. Also, if a beneficiary dies before the property owner does, the deed becomes invalid. Or if the intended beneficiary is a minor, then the minor can't manage or transfer the property until they reach the age of 18. There's no way to name a custodian or trustee to manage the property for the minor. You'd actually have to go to court and submit a petition in order to name a custodian on the property until beneficiary does reach the age of 18. So it provides no creditor protection. So a beneficiary could be subject to creditors' claims from a divorcing spouse, creditors, a bankruptcy trustee. So those protections are available in a properly drafted trust, but not through the transfer on death deeds. Also, title insurance could be invalidated once the deed is recorded. So, and then title insurance companies are unwilling to issue a new policy for 3 years after a beneficiary inherits the property. So potentially a beneficiary could be stuck with a property that they can't afford and not able to sell it for 3 years, stuck having to pay for the upkeep without the resources to do so. Also, a beneficiary who inherits the property becomes personally liable for the original owner's unsecured debts. So the beneficiary could wind up on the hook for the original owner's credit card debts or other unsecured debts. And also, the beneficiary is now required to inform all the heirs of the death and of the transfer on death deed. So that could definitely be problematic, and we could have some disputes arise from that. This is a chart that lets you know about some of the characteristics of transfer on death deed. So it does need to be recorded within 60 days of its execution. There are restrictions on the type of property. The transfer of the property must be recorded before death. And also a transfer on death deed can be superseded by a revocable living trust. However, it's best to revoke the transfer on death deed if you're going to be creating a revocable living trust. Also, the beneficiaries can only be a person, a trust, or a legal entity, such as a charity. If you have multiple beneficiaries, they will all be receiving equal shares as tenants in common. If one beneficiary dies before inheriting, then their portion would not go to their heirs, but rather to be split between the other beneficiaries named. You can't name any alternate or contingent beneficiaries if one of the beneficiaries that you name is unable to inherit. Then, like I said, their portion will be split between the other beneficiaries if there are any. So no ownership or rights are transferred during the life of the transfer. So you're not liable for any debts of beneficiary during your lifetime. And also the beneficiary receives the property subject to debts. So the property remains subject to any liens, encumbrances, leases, or debts of the transferor. And the beneficiary is also liable for the unsecured debts of the transferor up to the net value of the property at the time of transfer. Here is an example of how to complete the revocable transfer on death deed. It's fairly simple and straightforward. So you would just need the assessor's parcel number, or APN, need the legal description of the property, need the legal name of your beneficiaries and also their relationship to you. Then you just need to date, print and sign your name in front of a notary, and then have two witnesses who will also print and sign. Then you have to be sure to file that with the court clerk within 60 days of being notarized. And here is a fillable copy of that form, which makes it quite easy to complete. You can also revoke a revocable transfer on death deed at any time. And here is the form required to do so and an example of how to complete it. All right, that's all. Thank you.